The following program is for informational and educational purposes only. It is not to be considered legal advice. Fraudsters Radio was created to expose the many scams and frauds that have so infected society today. Scammers, fraudsters, and rip-off artists abound, whether it's scamming homeowners with bogus foreclosure relief services, dating fraud, incompetent lawyers, or consumer rip-offs. It's high time the public has a voice. If you work in a profession that deals with fraud, or if you believe you were or are a victim of fraud, you now have a radio listening public that wants to hear from you. Please feel free to message us through our Fraudsters Radio Facebook page, and we may have you on the show as a guest. If you'd like to call in for today's show, the number is 646-668-8512.
And welcome to Fraudsters Radio. This is Laurie Z, your host, Storm Bradford off today. And for those of you who have listened to the show before, we cover fraud. We expose fraud and scams, and we like to try to help you in situations where something has happened or to try and help you prevent a certain situation. And so I have a special guest today, Robert Childs from yourdebtsolution.org on. And we want to talk about debt settlement scams, like those commercials you see on TV that say, hey, you know, we're going to settle your debts for pennies on the dollar. You don't need to file bankruptcy, that kind of thing, because a lot of them are scams. So, Robert, I want to welcome you to the show first, and also, you know, kind of jump in and talk about your company, because you're a legitimate company, and how you got into this.
Yeah, thank you, Laurie, for the opportunity to talk today on your show. I've been in the business for before electricity, since the early 1990s. And it actually started when I was working for Bank of America commercial lending in the late 80s before getting laid off by banks buying banks, and fell into it completely by accident. Been in it since then. But my company specializes in, like I said, people who have a collection accounts, charge off collection debts, can't do taxes or student loans or child support payments necessarily, but credit cards, medical bill debts, things of that nature, that are haunting people's credit reports, especially if they're trying to buy a home. So we work in the world of settling those collection debts. But more or less, it was helping people. We do a lot of live presentations to large mortgage companies, real estate firms, and also a lot of webinars to educate the public. That's what I'm keen on, is really doing a lot of educating to tell the public this is what we do, what they can do themselves, and things of that nature to really get themselves out of debt working with collection agencies, especially if they're being sued.
All right. Now, what do you think? I mentioned those. I laugh. I'm sure you probably do too. When I see those commercials on TV, where it's at, they make it sound like it's a huge company and that they can, get you settled out for pennies on the dollar. And they don't really tell you how it works. Now, I know how it works. I know you know how it works. What do you think of companies like that, and why should people beware of companies like that?
Well, the first thing off the top of my head would be advance fees. You do not, NOT, capital letters, underline, in bold, pay a lawyer. It's like an injury lawyer. They don't take advance fees, only on conclusion, on performance. Some of these debt consolidation or debt settlement companies will try to charge you a setup fee, $300, $400, $500. One I saw for $999 out here in the Los Angeles area, and we feel that that's inappropriate. It's all based on performance. The person first off has to qualify for debt settlement, not to confuse it with debt consolidation. We'll talk about that shortly. But in the short run of it, people, after doing their research on that thing, they should never, ever pay an advance fee, not a penny, not a setup fee, not a reorganization fee or something like that, or a credit repull fee. Don't do that. Talk with that company first, check them out, and make sure, again, they charge absolutely zero upfront to take on your case.
Right, and I think a lot of the advertisements nowadays you read, they're too good to be true. And there's that saying, if it's too good to be true, it probably is. And I tend to be a very suspicious person when it comes to a lot of this stuff. And I want to read you just a little bit of information from an article in the Washington Post by Michelle Singletary. And so there was a company, let's see here, it's called Debt Pro 123. And they actually had a scam, making people think they could eliminate their debt in just a few short years. So apparently people had a lot of debt. And so according to the FTC complaint, Debt Pro 123 told people that its debt resolution program would completely resolve consumers' credit card and other unsecured debts, including department store accounts, personal loans, medical bills, student loans, and accounts with other collection agencies. And it claimed that it would reduce a client's total debt by 70 to 80% on average, including all fees, with settlements as low as 10%, meaning that a client could be saving as much as 20 cents on the dollar, including their fees. Now, that to me, because you and I are in the same kind of industry, we know that that's not right. But I want you to kind of talk about why that is a scam.
You can't read the future. If I had a crystal ball to look into, man, I would be rich on every lottery and scratch-off ticket from here to Kingdom Come, and it doesn't work that way. Now, when this is the way a debt settlement company should be approaching it, especially if they are what they call an FCRA attorney, known as a Fair Credit Reporting Act attorney that specializes in this stuff. I'm not a lawyer or a law firm, but I've been in the business long enough to know this. Now, when I'm looking at a client's credit report for a potential settlement case, and I say, for example, Lori, you have a debt here that you owe to a bank for a $19,000 charge-off. This is an actual case of mine. Client owed a bank, won't say the name of the bank, $19,000, but the debt buyer, known as a collection agency, purchased the debt, and they reported $24,500 on her credit report. So that's immediate violation of Fair Credit Reporting Act. So that said, after we got her case started, we were able to settle it for pennies on the dollar. But that was after the fact. We don't say that before we look at someone's case. It's case by case, credit report by credit report, person to person, depending on the situation. So we ended up resolving it for 9 cents on the dollar, and guess what? We got it deleted from her credit report because even though it was completely her fault for getting the debt, and she charged $19,000, couldn't pay the bill for whatever reason, but it got removed. So after we review the person's report, or any debt settlement company should be saying, yes, we can settle for approximately this amount. But even at that point, they shouldn't really be saying we can settle for this percentage. But we don't know. We don't know until after we get the debt settlement process started and start talking to the bad guys.
Right, and I think a lot of companies that people talk to that are on the scam side, they're just looking to bring in business no matter how it goes. There's that too good to be true type situation. They're telling everybody a blanket statement. The difference is you really can't make any promises because, in your case, you're probably dealing with multiple companies, but even with one company, you don't necessarily know how they're going to respond. However, when there is a Fair Credit Reporting Act complaint, which most people listening to the show, they won't really know what that is, but it's when there's a credit reporting issue that's not legal, basically. You're looking for leverage then to say, whoa,
yes,
Mr. ABC Company, you screwed up. And based upon that leverage, now that gives you negotiating power. You can't just say, hey, we can take all your debts and make them disappear, correct?
No, you can't do that. No. There will be a case from time to time where if there is a major FDCPA, FCRA violation, I'll explain what that means to the audience here in a moment, that there's a chance. It happens from every once in a blue moon where a debt's completely waived because the creditor is so scared they give up and say, okay, we give up, throw the towel in, and we'll delete it from the person's report and the client pays back nothing. So, but on average, we don't know what that percentage of savings is going to be until we start talking to the creditors and collection agencies on the client's behalf. So some of the warning signs that people should be looking out for is, number one, advance fees. Don't do it. Even a law firm, should not even be charging advance fees. The only law firm that could charge advance fees is a bankruptcy attorney, based on their own state laws. But any advance fees. Number two, like you said, Lori, promises. I can promise to get this down to, 80% reduction, 70% reduction. We can save you this. Another third one is the tax consequence, a 1099 a tax consequence. I heard some debt settlement companies say, we'll make sure that the IRS doesn't send you a 1099 for that difference in the debt settlement. They can't do that. They're not the IRS. So in short of it, those are really the top two, advance fees and promises. They can't. You just can't do that. Even after I examine the report, and I know the client better than they know themselves by looking at their credit report, you still don't know the outcome until the end of that resolution process.
Okay, now when you look at the report and you get the story from the client, do you ever also, I know also the Fair Debt Collection Practices Act, that additionally can give you leverage, correct, in trying to negotiate out that report. And especially, we want to also talk about getting it deleted and what that means. But knowing the Fair Debt Collection Practices Act can also help in getting something reduced or deleted. Oh, yeah.
And with the audience, to kind of tell you with all these acronyms, FDCPA, the Fair Debt Collection Practices Act, recommend you Google that so you get a better idea of it, means it's what's going on between the creditor or collection agencies and the customer. So, for example, if they're calling it awkward times, they call it too many times in a given day, they're outside the federal statute of limitations of that collection debt, for example. I can go on for an hour about that. That's an FDCPA violation. So FDCPA has to do between the consumer and the creditors. FCRA, the Fair Credit Reporting Act, is really between the consumer and the credit bureaus. So think of it like this upside-down triangle. And sometimes the FDCPA and FCRA do connect. They do bridge together in some fashion. But, Laurie, as you said, yes, FDCPA violation, FCRA violation, you bet. We can use that to the consumer's advantage in their favor to get a super, super low settlement. Now, a consumer can sue the credit bureaus or the creditor collection agencies for a violation of either one of those acts. But it could take months. So if you're in the process trying to buy a home in the next month or two, be prepared of the time frame that could be involved. But settling it can be to the client's advantage for a very low amount.
Now, as a legitimate company, do you use the TCPA, the Telephone Consumer Protection Act, when they're getting the robocalls and things like that as leverage as well?
Once in a while, Laurie, TCPA violations it is hard to prove unless a person has voicemail after voicemail or, because if someone calls and hangs up, it really doesn't constitute as a TCPA violation. But, we will mention that time to time. So my company mainly focuses on the FCRA. I would say about 90% of what we do when an FCRA violation case is seen or caught, that's what we do. 50% of the time it's FDCPA, but rarely TCPA, Telephone Consumer Protection Act.
Right, and I don't know if you're aware, but that law may kind of disappear or be reduced as far as damages. We had an attorney on last week who was talking about that, and while right now it can still be effective, that law may disappear or, like I said, be reduced where it won't be able to really help people that much, which is a shame because, most of us get those phone calls. Right. Well, I get them all day long, and it's really pretty annoying. Now, I just want to mention, but we're going to go to break in a couple minutes, but on this particular case with this Debt Pro company, it says in Phase 1, customers put money into a creditor fund settlement account and told they needed this pot of money for negotiations with their creditors. And then in Phase 2, the customers were assured that the company was working on their case to get all their debt terms changed, like that would happen. During these phases, customers were advised to stop paying their bills, stop all communications with their creditors. Well, you know what happens when you stop paying your creditors. Why don't you explain what happens on the credit report?
Oh, absolutely. Folks, if you have, for example, let's say 3 credit cards at $5,000 a piece limit, and they're maxed out, so you'll $15,000 amongst 3 credit cards. And if you stop paying it, you'll have a couple lates that start appearing in month number 1 and 2, rolls up into a 90-day late by month 3 and 4. And if you have 6 continuous missed payments by the 7th month, it gets charged off as a loss. So it will really destroy your credit, especially when you have on-time debt. So be careful. If you're making the minimum payment, like I said, if this company is telling you to skip payments, something that we'll never, ever do, or tell a person to file bankruptcy, But beware that if you start missing payments, even a single late can drop a credit score, 10, 20 points on average, maybe more, maybe less. So imagine being 90 days late or charged off. It can really do some serious damage, folks, to your credit score.
Right. I've seen from mortgage brokers, they can run a simulator, what happens when they make a late payment on an account. And actually, it can be a score hit of 30 to 100 points, I found.
Yes.
On a mortgage payment, it can be 1 to 200 points, which FICO actually revealed. Now, I want to continue on, but we do have to go to a short commercial break. We're going to be right back with Robert Childs. Stay with us.
Have you received a notice of foreclosure on your property? Do you suspect that you're involved in an unfair or fraudulent loan agreement? Are you looking for a way to save your home? Would you like to cut through all the misinformation and find out what really works? Would you like to learn strategies that the so-called gurus aren't aware of? If you answered yes to any of those questions, a professional team at Mortgage Fraud Examiners can assist you and your attorney with all of these things and more. Contract breaches, errors, statutory regulatory violations, fraudulent appraisals, and other fraudulent conduct cause most mortgages to be legally problematic. In fact, the Federal Deposit Insurance Corporation found that nearly 2,000 financial institutions they assessed received citations for significant compliance violations. They also examined appraisals and found out that of the 259 appraisals reviewed for accuracy, only 7 fully complied with professional standards. Call us at 844-920-7200. That's 844-920-7200. Mortgage Fraud Examiners, 844-920-7200.
And we are back. I'm Laurie Zuck, your host today for Fraudsters Radio, special guest Robert Childs from yourdebtsolution.org. Now, Robert, people tend to lump things together. Like I'm a credit education specialist. I teach consumers how to do it. I don't do it for them. Then there are credit repair companies. Like they come up with different names. Now, with your debt settlement, but there are also debt consolidation companies and credit counseling companies. Can you talk a little bit about the difference of that? Because I actually have a story I want to share, but I want to hear what you think about the debt consolidation companies and the credit counseling companies, and maybe why they're not so good.
So, there's some good ones out there and a lot of bad ones out there, profit, for-profit, non-profit. So debt counseling maybe one of two ways, either like a kind of like a do-it-yourself type of approach, which is good, it's very time-consuming, or, they will do it for you for a minimal fee. Usually they're nonprofits, and they will contact the creditors. Debt consolidation for a for-profit, what I found out, at least 70 to 80% of the time when people come to me for debt settlement after they had experienced a bad debt consolidation, same thing over a period of many years to pay it back, 3-4 years, is that they'll consolidate, negotiate with your on-time or collection creditors' debts. So, for example, if someone had $10,000 in collection or on-time credit card debt, your minimum payment, for example, is $250. They come in saying, okay, now your payment is going to be $125, half of that for the next several years. Well, not knowing that the payment really should be $150, not $125. And over the course of the next 12 to 18 months, you're experiencing lates and past due on those accounts. And because it's going over the next year and a half, it's going to serious past due under the debt consolidation program. These creditors are going to call you saying, Laurie, you're late. You owe this much money, and collection letters are going to start showing up, or even collection agencies. And you say, well, wait a minute. I'm in a debt consolidation program. They found out that the payment came in too short. What it should have been is $150 in that example, not $125. So debt counseling, depending on who you use, could be good, could be bad, depending on that. But the one thing with both services, it takes a long time, like I said, 2, 3, 4 years, sometimes 5 years on average. And it will put on the trade line and the comment line, this account is in a debt consolidation program. Well, when you run your credit, a few years later to buy a mortgage, the lender thinks you're filing for bankruptcy. It's actually coded like a bankruptcy in some cases with some lenders. So that could be a bad thing. So, debt settlement means right now, next couple of weeks, 3 weeks at the most. Debt consolidation or credit counseling over a very long period of time. So there's some, like I said, there's good ones out there, a lot of bad ones, but you have to do your research and homework if you're going to take on one over the period of time to pay it back.
Right. One of the things I found is anytime I'm going to do business with a company, I try to find out about that company. I don't just go necessarily, especially if it's the first company I'm calling for something, and so one of the little tricks that I do when I Google the name of the company is I'll Google it with the word fraud and or scam and or complaint and or ratings, those 4 terms, because that will give me a lot more information. It's not going to just show up on the company's website if they have a crappy reputation. So I think you have to really look at a company or look at more than one company for what you're deciding to do. Now, just to share a little story, probably 10 years ago, I had referred a client to one of these debt consolidation companies. I don't even think I actually had looked at the contract, but it sounded like a way out for someone who was seriously in debt that didn't want to do bankruptcy. And unfortunately, what ended up happening, and this is the only time since then I've never done that. I don't even know if this company's still in business, but what they did was they were collecting, let's say you owe $10,000. They would want $5,000, and of course you don't have $5,000 if you're in trouble. So it would be collected over a period of time, and then there's their fees. So they would want all that money, which could take you 2, 3, 4 years, maybe longer, to try to accumulate that money for them to then go ahead and negotiate with the creditors. But meantime, the creditors, they're never contacted by the company because the company is not a lawyer saying, hey, we're going to call everybody. So what would happen, and this was a big thing a few years ago, I used to read a lot of articles on it, well, what ended up happening was the companies, the credit card companies, for example, they wouldn't be contacted by the debt consolidation company because the client hadn't put enough money into the account. So they would get sued. They go, hey, we don't care if you have a debt consolidation company. We haven't heard anything. And so now, the client would have to go out and pay money to get a lawyer, or they'd have to file bankruptcy. And that, to me, was a huge red flag now. So, if I look to evaluate a company, I always tell people you got to read the contract. What are the terms? And if you don't understand them and they're not in layman's terms and it looks like it's all legalese, to me that's sort of a danger warning sign. What do you think?
Oh, absolutely. Yeah, I mean, everything has to be disclosed if it's a simple agreement or a lengthy contract. You may even want to have your own lawyer look at the contract before taking it on because it can be very, very wordy. So, yeah, it's very dangerous if they are not. I mean, let's put it this way: if you're paying a company over, $5,000 in fees for a $10,000 debt, for example, and it takes you 3-4 years to pay up that $5,000 to their so-called escrow account, by that time, the creditor might even reach the statute of limitations. And the person doesn't even have to pay it back at some point.
Right.
So it's really funny how that works
interest.
out.
Yeah, it may have accumulated interest at that time also. Yeah. So people don't realize that. So, one of the things I do, like if I'm looking at a prospective client's credit report, usually for me it comes from a mortgage person. Sometimes I just have a heart attack. I'm thinking, how can the mortgage person think this person could even qualify for a house? Because I don't know if they just don't tell the mortgage people, but they'll tell me. I had one, Robert, where it was 2 women wanted to buy a house. They only had $12,000, but they were in debt for much more than that, and neither of them were working, and they wanted to buy a house. It's not gonna happen.
Right.
But one of the other things too is bankruptcy. So if a client is way in over their head, then I think that they should talk to a bankruptcy attorney. However, if they're working and they're making a decent living, if you go Chapter 7, sure, it can wipe out your debts if you qualify for that. And a lot of Chapter 13s, which are the reorganization of debt, end up as Chapter 7s. But I think the Chapter 13 reorganization of debt actually makes your credit worse because it's a 3 to 5 year payout. Time that you're paying out, it's going to be a total destroyer of your credit. And that's a case where a company like yours can go ahead sometimes and be able to look at it, talk to the client, look for the leverage in the Fair Credit Reporting Act or Fair Debt Collection Practices Act, and actually negotiate those out and hopefully get it deleted off the report. Now, I want you to talk a little bit about what happens on a credit report when an account gets deleted, or how it gets marked, paid in full, paid as agreed, paid as settled, collection account, that kind of thing, because that's a key thing. I know you're trying obviously to save them money, but at the same time you're also trying to help benefit their credit report, correct?
Absolutely. Yeah, we have to take a look at in terms of the benefit of the consumers, three major credit reporting profiles. First off, my company doesn't touch client money. We settle you owe $10,000, for example, and we get down to $3,000 payoff. The client's going to pay go involved, so the client feels safe that their money is going to go from their pocket to the settlement pocket. But in short of it, if an account gets, let's say it's a collection account, and ABC collection agency says, yep, upon receipt of the reduction payment, we'll be more than happy to delete it. Remember, folks, if you're doing this yourself, never take their word for it. Get a projection letter that says they will delete it upon receipt of your settlement payment. That's what we do. That's important. But if it got deleted, you're going to have a major improvement in your FICO score, much less if it just said settle for a lesser amount with a zero balance, or better yet, the next best thing, paid in full, paid as agreed. And, of course, the top one would be we want to try to get that deleted. But even at the minimal worst-case scenario, you owe 10, they settle for 4,000. It will say settle for a lesser amount, but it will show a zero balance within a few weeks. And that can have a major positive improvement in your credit score. How many points? Might be 50, might be 100. I can't tell. But it will definitely have a positive improvement.
Right. Now, typically in a good agreement, I'm sure like when you're doing is when you come to an agreement, let's say it's a $10,000 debt, and you maybe get a settlement out, let's say $3,000 or $4,000. What happens to the remainder of that debt?
It is forgiven, but the consumer has to be aware of that there could be a 1099 consequence involved in that. So, for example, if you owe $10,000 on a charge-off credit card debt and we settle for $4,000, there's a chance. So it could be I can use a safe number, 50-50 chance that they'll report that settled waiver of $6,000 in that example to the IRS. And next year you could receive a miscellaneous 1099 for that as income. So before you do any type of debt settlement, please talk to your tax advisor. It's very, very important, guys, that we don't want you to, if you own rental property or other investments or things like that for write-offs, this could affect that positive or negative. So please check with your tax advisor, CPA accountant, before doing this. But like I said, it's roughly about a 50-50 number on, that they will report it to the IRS.
Got it. Well, if you have a good accountant, sometimes I know there are ways that they can waive it, but that's where, people have to, they don't necessarily want to spend the money to get a good accountant. That's a whole other topic. But if you don't have a good accountant, or you have one of these, companies that appears once a year, and I'm sure you know who I'm talking about, they're not really trained CPAs or accountants, that went to school for it and keep up with their continuing education to know how the laws change each year. And I think that's really important, especially when it comes to this kind of situation.
Correct. Yeah, correct. I don't know if you want to trust your local H&R Block agent. They may not be trained, like you said, to do that. But, tax attorney, if you have one, they're expensive, or just a regular accountant, family accountant you've been using for years, or get a good recommendation from a good friend or neighbor, can probably save you a lot of headaches from the IRS. But it's about what I've seen over the past several years. It's a 50-50 chance that, depending on the size of the debt too, that it could be reported. Only credit card debt, guys, not medical bills or an upside-down automobile loan, that goes in a repossession mode, but just mostly credit cards.
Now, before we get a commercial break in a minute or so, can you just quickly tell me what kind of debts do you settle out and what don't you settle out?
We will work with unsecured debts, mostly credit card charge-off debt. It must be in collection. We will not settle a debt if it's a few late payments or on time. Can't do it. Collection debt, charged off credit card debt, collection medical bill debt, and also when a car gets repoed and they owe the difference after it's sold at auction. We can also work with business debt, unsecured business credit cards, business loans, and lines of credit that may or may not show on the person's credit report. The debts that I just won't touch is child support payments, state and federal taxes, and certain student loans. When I do say certain student loans, meaning government loans, Sallie Mae, Department of Education, for example, but private loans that got to a hands of a private collection agency, we might be able to do. So private student loans, it's to be announced based on the person's
No,
debt.
That's all right. You pretty much stay away from the government stuff. I mean, that's a whole different ballgame, right?
Yeah, that requires a law firm. Yeah, that requires specialty stuff. Yeah.
Got it. Well, I want you to stay with us. We are going to do a commercial break. When we come back, more on debt settlement. Stay with us.
There is a very high likelihood your mortgage contains an extensive error. At Mortgage Fraud Examiners, we know just how costly a missed opportunity can be. For almost 40 years, we have consulted, retained, and referred to by attorneys, lawyers, trial practitioners throughout the nation. Put another way, we are the trusted source for litigation support. A foreclosure is basically an allegation the homeowner breached the contract by failing to make timely payments. The contract is clear. The borrower promised they would make timely payments, and if they didn't, the lender could take the property. The only way to overcome the homeowner's breach is to show the lender breached first. Identify errors that would void the contract. Identify regulatory violations. Identify appraisal fraud and other fraudulent conduct. And the only way to find these wrongs is to thoroughly examine the whole mortgage transaction. This meticulous examination of your mortgage transaction and appraisal can identify legal defects that would make your mortgage unenforceable and entitle you to compensation or even free title to your property. Call us at 844-920-7200. Mortgage Fraud Examiners. That's 844-920-7200. 844-920-7200.
And we are back on Fraudsters Radio. It's Laurie Zook here with Robert Childs from yourdebtsolution.org. And we've been talking all about debt settlement. If you have a debt settlement question you'd like to have answered by Robert, please call into 646-668-8512. Now, Robert, interestingly enough, I went to the Federal Trade Commission site to look up some of this information. And so I'm going to read you just a little bit because it's actually saying what you're saying. Other companies may try to collect their own fees from you before they've settled any of your debts, a practice prohibited under the FTC's telemarketing sales rule for companies engaged in telemarketing services. And it talks about how some of the companies fail to explain the risks associated with their programs. And so here's what they're saying. Avoid doing business with any company that promises to settle your debt if the company charges any fees before it settles your debt, touts a new government program to bail out personal credit card debt, guarantees it can make your unsecured debt go away, tell you to stop communicating with your creditors but doesn't explain the serious consequences, tells you it can stop all debt collection calls and lawsuits, and guarantees you your secured debts can be paid off for pennies on the dollar. And that's why I said, every time I see these commercials on TV, I laugh. It's sad, but I laugh because it's a joke what companies will say. But what's actually more disconcerting to me is the fact that the Federal Trade Commission, while they tally up companies who don't abide by these rules, unless like one particular company has a major problem and you've got 1,000 complaints within 1 week, all they really do is tally and change the laws. The biggest thing I find is no one really enforces the laws from the Federal Trade Commission. Again, that's my opinion, but I'd like to know what you think on that. Why do these companies get on TV? Because down the road, then they're on the news when they're in trouble.
Yeah, true. And if they do get at the FTC, and guys, keep in mind, for every probably 100 advertisements somewhere going around North America, including Canada, it's the FTC so backlogged. Imagine being at the border of Mexico and you're standing in this 3-hour line and trying to get back into the United States, and you're trying to detect for drugs, and they catch less than 1% of those cars that are trying to bring drugs into this country. FTC is the same way. they're so backlogged, they're so understaffed, underpaid, I would assume, that it's impossible. And the company can advertise one day, get sent a fine for $50,000, for example, from the FTC. They file for bankruptcy. They pay nothing to the government. They open up under a different name. So It happens. It does happen. Just have to do your homework. Be careful when you talk with them, check them out as best you can. But the bottom of the end of the day, bottom line, they should not be charging any fees up front, zero.
Right. Now, we were talking about, or we were both talking about the FTC not having enough people. Now, interestingly, we've also had the IRS on this show. We've had the FBI on this show. And when we covered those topics, their representatives basically said the same thing. So many people are getting ripped off. I don't think it was this way, maybe 30 years ago, 40 years ago. I don't think there was as much criminal endeavors, as much white-collar crime as there is now. And so these agencies, while they're set up as a protection mechanism, really it's more of their public relations as far as telling you, what to look out for. But when it comes to actually enforcing, if something goes wrong, you can report them, and you should, because if they get enough complaints against the company, maybe they can suspend their license or put them out of business. But you're right. Then they go ahead and they do the same thing, and yet how do you prevent those same people from closing up shop in one state and going to another state? There's no bad guys list, so to speak, between states where there's reciprocity, for example, where they just go ahead and continue to do the same thing. And so one of the things, if you're dealing with a company, maybe find out how long they've been in business, what's the history of the company. But really, you have to do your own due diligence nowadays, right?
Yes. Yeah, most definitely. As for references, I mean, we have a lot of corporate references that we use, for example, from mortgage companies, CPA firms, real estate firms, other credit repair companies, for example, good ones that are out there that we worked with. But certainly they're not, refer to consumers about that. But certainly do your homework, do your research on that thing, ask a lot of questions. But in the day, if they say your application says, $299 setup fee, run away like it's the plague. Don't do it.
Yeah.
Look elsewhere. Yeah.
Exactly. And I think, if you check also in your state with the Attorney General, if you don't know who to call, because every type of business is pretty much monitored in some way by some agency, call the Attorney General in your state and tell them what your problem is. And they can typically tell you who you can call and file those complaints with. And I would say don't just do it as a phone call. Do it in writing, certified return receipt in mail. Get something on paper that maybe gives you some type of guidelines, because on a phone call you may not remember everything that they're telling you. Now, another topic I want to cover with you are disclosure requirements. So obviously every company should have a contract, a written contract that discloses things like, the price, the terms. Now, this one's interesting from the FTC. It says results. The company must tell you how long it will take to get results, how many months or years before it will make an offer to each creditor for a settlement. I don't think that happens a good portion of the time, does it?
No. And again, it all comes down to that crystal ball effect. A bad or good company can't really tell you that. I mean, dealing with one collection agency, I had a husband-wife scenario, for example, just a couple of months ago, and they owed American Express, I'm going to say the bad guy here, $12,000, $13,000, and it was funny. We had to negotiate for both of them, even though it was a joint account, and it took about 6 weeks to settle it. It's usually on average take half that what I see in my client base, but you just don't know. You just don't know. One collection is more difficult than another. Some collections won't even talk to debt settlement companies unless you're a law firm. So we have a list of those things that we can't do. So read the future. We just ballpark saying on average our clients experience 2 to 3 weeks. But it may take longer. I did one in 1 hour. So it just depends how easy that debt buyer, law firm, collection agent, or creditor is easy to work with. So, but it doesn't take that long. It does not take that long at all. But sometimes you have to be forewarned that it can take months, just depending on how stubborn the creditor is.
Gotcha. Now, typically, a company, I know, like with you, you take a limited power of attorney to be able to deal with. You have to, because you really,
yes.
For the consumer themselves, and I know this too because I've done a lot of debt negotiation. You could explain it all you want to just a regular person, but if they haven't been doing it for years and years, they don't really know what to say. And sometimes on the phone, it's a recorded call, so they can actually put their foot in their mouth, so to speak, and now make their situation worse. And I can tell you, I've had clients call me, or prospective clients saying, "Well, I just called up all of my collections, and I paid everything off, or I'm trying to negotiate." And they may be revealing information that could be used against them in a court of law if it's within the statute of limitations of that state. So, what advice would you give, other than what I just said? What would how do you explain to people calling up? Because I know why people use you. But what would you say to someone who maybe is nervous? They're going, debt settlement, I hear all these scams. What would you say to them?
Well, think logically, folks, not emotionally when you're dealing with these things. I know, hey, I'm trying to buy a home in 45 days. If I don't do this, I'm going to, be renting the rest of my life. Think logically. Breathe before you call these guys. And like Laurie said, it's being recorded for quality assurance. Best thing is, number one, is never admit it's your debt. When you call them up, and I tell people how to settle their own debts for free. I'll give them advice all day long. It's time-consuming, and it can be nerve-wracking, but it's very time-consuming. But never admit it's your debt. For example, never call up and say, "How much did you say I owe?" "Oh, I owe $5,000. You just admitted to it." And if that happens, yes, they got you recorded, and it can be used against you. Like I said, if it were to go to court at a later date, future date. So you could say something like, "What's the alleged amount that you say is owed on this?" So you didn't use the word I or me. So how much did you say is allegedly owed on this account? And how much is principal? How much is interest? What's the fat on the steak? Things like that. So I'd actually have anyone at the end, I can give them my email address or phone number, but I have a short list of the do's and don'ts questions that you can actually read from if dealing with these collection agencies. One thing is, if it got turned over to a law firm, what they call it, and you got some legal papers in the mail, if you already been sued and they garnished your wages, levied your bank accounts, or put a lien on your house, there's not really much we can at that point, because they're going to get paid 100% plus their fees. But if you've been served legal papers, it's still possible to settle it with that law firm. They're not a debt buyer. Still possible, but a little bit more difficult to get a really low settlement, but doable at that point. So don't be scared. If there's no court date set up, we'll call the intent to sue, but you receive legal papers either certified mail or by a process server shown up at your front door, it's still possible to negotiate.
Right, and one of the things, too, I can't quote the source, but I remember reading articles over the years, and they all say the same thing. About 90% of people who get sued on credit card debt don't even show up in court, and then they get a default judgment against them. What advice would you give to somebody, who because, my advice would be, you got to open your mail. Some people don't even open their mail when they see, they don't know what it is. So if you're getting served and you don't show up, you have automatically lost the ball game there, and now you'll have that judgment against you plus the attorney's fees. So what would you say to somebody that does that other than open the mail?
Well, please show up in court. You see, guys, winning a judgment against the consumer it's easy for the creditor to do, because obviously your signature's on the application, the receipts that you use to make all those charges. But if you don't have the financial ability to pay it back, they can't squeeze a dry sponge. Good analogy. But keep in mind that you can actually ask the judge, okay, let's say you're in court October 1st. Judge, I need a little bit more time to talk to legal counsel. In the state, like in California, they might give you 6 to 9 months. And guess what? I had a client that did that, not knowing. After 4 years, it reached the finish line under the federal statute of limitations, and the case was dismissed. That happens rarely, but you can ask for more time. Maybe you might want a lawyer there with you, for example, which could be costly. But please show up. It's very, very important to show up. If you get legal papers in the mail, on a certain court date. But remember, the first papers you will receive is the intent to sue. That's before the actual court date is set up. But you must reply. You must show up in court because it can cause you more problems down the line.
Right, and those people who are trying to buy the house now have a judgment against them, which looks even worse. And nowadays, I don't know that a lot of people are aware, but the judgments, for example, are no longer showing up on a standard credit report. The mortgage people are doing a public records check, in the background before it goes through, so that they can see what public records you have, what judgments you have against you.
Yes.
So I'll get people who call up and go, well, it's not on my credit report, therefore, look, my scores are great. And I'm like, well, sorry to disappoint you, but they're going to run that background check, and they're going to see those judgments. You don't want to get to that point because then it's costing you even more. And typically companies, unless it's a very old debt and they know, I think most judgments run about 10 years, and then you can renew for another 10, for example, just as an average. The older the judgment is, probably the better chance you have of even negotiating that. I know I don't know if you do that, but you can still do that on a judgment. People may not be aware. That judgment creditor doesn't have to accept that, but sometimes they do.
Mm-hmm. That's true. Yeah, that is true, depending on the age of it, the size of the debt, things like that. Now, if someone is not sure that, 7-8 years ago I did have a few credit card large debts, balances, and collections, only way to know is to contact your local county courthouse clerk's office. Call them up and saying, my name is, middle name included, social is, date of birth is, to cross-reference it. Do I have anything on file? Yes, you do. Go down there, get a copy of it, because especially if you're trying to buy a home, if they mail it to you, it could take weeks to get to your doorstep. Go in person, pick it up, show your ID, and then you can work from that point. But if there's nothing on file, that's good news, especially from a mortgage perspective. They're going to check, it's not only your credit report, but they may check what they say with public record.
Exactly. All right, well, let's do one more commercial break, and we'll be back in just a moment.
Consumers, do you have bad credit? Can't purchase a house or car? Paying too much in interest on your credit cards and loans? Scammed by credit repair companies? There is hope. You can get back on track and do it the right way. Call Credit Education Consultants today at 813-500-6064. That's 813-500-6064. Or go to crediteducationconsultants.com now and get the help you need. Don't delay. Call today. Mortgage reps and realtor inquiries are also welcomed.
And we are back on Fraudsters Radio. My guest, Robert Childs. And, we've been talking all about debt settlement. We talked about how you could check companies out, even Google. But one of the things, and again, I told you years ago I had referred to someone I knew that was actually doing it as an affiliate. And now my opinion of affiliates has changed to the negative. Not that this person was a bad person, but typically affiliates, they don't really necessarily even understand the intricacies of what it is they're selling, correct? So they may think, hey, I'm doing a great service for people that are in debt, but what's the reality?
Well, if they're an affiliate of a debt settlement, debt consolidation company, or a law firm, I've even seen that happen, they have to have a clear understanding of state and federal laws pertaining to it. It changes. What the do's and don'ts of FCRA, FDCPA knowledge as well. And if they're using for example, they're an affiliate and they're using ABC Corporation, but in the background in their contract, they may be working with XYZ debt settlement company. They may need a license or some kind of surety bond in that state, depending on where they're located and the business model of that company. So even credit repair companies are set up the same way. So they may not be doing it in the best interest of the client. My people work for me. They're on my staff, my payroll. We're not affiliates or a franchise or anything like that. So it's important that you're talking with the source, not some third party.
Right. I'm going to read you one more thing from the FTC's website. Actually, this one is from Good Financial Sense. It says, don't politely, one of the things it's talking about, if a sales associate from a law firm pitches you on their program and then asks to set up a face-to-face meeting, you can pretty much bet that they're going to charge upfront fees. which is exactly what you said. So do you think, are there still lawyers that are actually doing this? Even maybe it's legal for a lawyer, I don't know. Or is it not legal for anybody to ask upfront fees?
Well, if it's for educational purposes, and so I know of a really, I won't say the state, a really national FCRA law firm, but really we've been working with them for potential FCRA lawsuits, for example, against the bad guys. And they have a completely different nonprofit organization. It's not even associated with the law firm. That's educational purposes. So they charge for webinars or live classes at their headquarters here on the West Coast, things like that. That's legal. But if they take on their services, then that money that they paid to the nonprofit education service goes towards the end of the process fees. See, so it depends if it's education, but if it's for the actual service guys or before services are performed, beware. Don't pay it. For educational purposes, maybe, but for services, no.
Okay. Now, do you find, certain companies, I can think of a few right off the top of my head, do you find certain companies are harder to negotiate with, even if you have leverage, that they just don't want to do it no matter what?
Yes. Yeah, I won't say the name of the collection agency, but they're the biggest and oldest in the country. In fact, this certain one sometimes won't even talk to me because I'm not a law firm or a lawyer. And only way to negotiate I'd actually have to do a three-way call with the client. So that they're talking to the client. So some of them are difficult, even if there are no FCRA violations, for example, just plain old good negotiating, to try to negotiate a lower amount for the consumer. But yeah, there's a handful that just talk to us. Yeah. And if I see a client's credit report, I'll let them know, hey, this one right here we can't talk to. They just won't talk to us without doing a three-way call, for example. So that might need a little time with the clients to try to negotiate a settlement on those particular collection agencies.
Right, and I want to talk about also each state has a different statute of limitations for debt collection, which you can look up online for your particular state. Let's say I'm here in Florida, it's 5 years. So it's 7 years, though, for it to come off the report on non-governmental debt. So do you find that generally it's easier if it's past the statute of limitations because the company can't sue you at that point, but there's still 2 years left to stay on the credit report? Do you also find that those are typically easier to negotiate?
Oh, yeah. Yeah. If your underwriter, for example, at your mortgage office saying, okay, client, you have these 5 collection debts, but these 2 right here are 4, 5, 6 years old. We don't care if they're showing or not. I'm just going to leave those alone. Why spend the money to settle it? Let me put it this way. Let me back up. Settling, right. If an underwriter says, we don't care about those $10,000 or medical bill collection debts, we're just going to approve your loan. But from a FICO point perspective, your credit score, it will improve. I don't care if it's a day old or 6.5 years old by settling it, because you're chopping off the dead weight. That will improve your FICO. And if lenders are FICO score driven, yes, that will help. But if your FICO score is good enough and you got, okay, we'll settle these 3 debts and leave these 2 alone over here. Let's focus on those 3. That will save time and money for the customer.
Now, can you maybe give me like a couple of good stories that you've had? You don't have to mention clients' names, of course, but give me a couple of good scenarios that you've had. Oh,
yeah. I had a client in Hawaii, and I'll say the name of the creditor, First Hawaiian Bank, and the client owed $29,000 on a charged-off Visa debt. And we found some minor FCRA violations on the credit report, not big enough to sue them, but big enough to use them to the client's advantage. And we ended up settling for $9,000. So this was December of last year. And ended up that because of that violation, and remember, when they're talking to me, I'm being recorded for quality assurance, said, listen, if you guys 1099 this client, there could be some legal action against your bank. And guess what? The client, as of now, never received a 1099 for that difference of $20,000 that was forgiven. So that happens time to time. Client was being sued for a credit card for $12,000.
Okay.
I forgot the name of the bank. Found out his name was Joe Smith, Long Joe Smith, with the same birthday and similar social. How ironic is that? And they messed up his credit. So we ended up.
Oh boy.
Not only because it was identity theft, so to speak, not really identity theft. The whole thing got raised.
File.
Yeah, but we ended up getting a law firm involved, and they settled with him for a few $1,000. I didn't charge him a fee for that because we didn't do anything. We just referred out to the law firm, but it worked. And, we have a lot of stories like that where clients are just now higher credit scores because, guys, the fastest way to improve a FICO score is a possible settlement of these collection debts. It's faster than even paying off credit card debt.
Yeah. But you know what the funny part? You're mentioning something, and I had a story where I had a guy with a common name lived in an apartment complex and lived with a guy with the same last name, not related, next door. And their credit reports both were a mess because the credit bureaus pick up similar information in that database, and because they have the same last name and live next door. And so I think another tip coming from credit world here is before you negotiate anything, you have to make sure it's actually your debt and that it's a valid debt. And, that's where you can demand validation and request, basically produce the documents. Show me what I signed. Show, what you claim I signed, alleged. An itemized statement or contract, something. I can't tell you how many times clients will say to me, I think it's mine. I think it's mine. I'm not sure. I think it's mine. And then when the documentation comes back, it's not theirs. So, it's not really identity theft because usually they're getting phone calls from collectors, if it is.
Yeah,
right, but when it's the merged file, you could have someone where it's the same name but a different middle initial. And so I think before you do any negotiation, you have to look at your credit report, look at all the personal information to see what are the name variations, were there states you didn't live in, phone numbers, things like that. The personal stuff, that's kind of a red flag to me when I see, there's a different name, or if I Google the person's name and it says, there are 183 people in the United States with this name, there's a possibility that something went wrong there. Now, before we go, we only got a couple minutes, so before we go, when you do negotiation, is it better for the client? Is it typically better for them to have you do a lump sum type payment when you negotiate? Because I would think that doing a payment plan, that would be much more difficult to negotiate regarding the credit reporting end of it, correct?
Yes. If you're trying to buy a home and you say, I want to buy a home, you have a realtor that found a beautiful house for you, and let's go in 45 days. Let's say, for example, $10,000 debt, I get down to 3, save you 7%. And the creditor says, okay, we'll take $500 a month for the next 6-7 months until paid off. Remember, guys, it may show all the past due showing current on that collection account on your credit report, but it's going to show a balance until the last payment's made, meaning that it may affect your debt-to-income ratio possibility of getting declined for that mortgage. So when we talk to clients, they should pile of cash sitting aside, borrow money from mom and dad or retirement plan, whatever they can do. But when we go in and we settle it for that $3,000, they want that $3,000 because that way they'll show a zero balance on your credit report, improve the FICO, go get your house, for example.
Yeah, they want their money right away, and then you get the agreement from them, which the client can get a copy of, just in case something pops up on the report years and years later. Well, we've given out some really good information, and so what I'd like you to do is, again, tell us who you are, give out your website, your email, your phone number, information about yourself.
Yeah, my name is Robert Child. My company is Your Debt Solution, no S on the end, .org. It's not a nonprofit. It was just the domain name that we chose. yourdebtsolution.org. My phone number is 949 area code 371-85. I'll repeat that. 949-371-8885. We're located in southern, beautiful Orange County, California. I'm near Disneyland. I can hear the fireworks every night at 9:30. And we work nationwide, and again, we will give a free consultation. I would recommend someone, get a copy of their credit report from annualcreditreport.com. My email address is info at yourdebtsolution.org. Email me your credit report, and we'll call you back. Myself and my team members will call you back, give you a free consultation, talk to you about what we can do or not do, and see if the person likes to move forward. Yeah.
Excellent. You've been a wealth of information. I want to thank you so much for joining us on the show. Really good show today.
Thank you.
You're welcome.
Thank you for your time. Look forward to the future one.
Yeah, excellent. And for our listeners, thanks for joining us today on Fraudsters Radio. Please join us again next Monday from 1 to 2 Eastern Time live. And remember, we want to hear your stories. You can contact us through the Fraudsters Radio Facebook page.